Zoning Board of Appeals for the City of Troy. I would like to introduce everyone up here on the dais for those who are in the audience or who are watching at home on the internet or on cable later this week. Over here to my left, your right, is Mr. Lambert, who is a member of the board, and then of course to his right is Vice Chairman Eisenbacher. This is Ms. Kupa, who is member of the board of here, but she's also a planning commissioner for the City of Troy. I'm Glenn Clark, the chairman and presiding officer for tonight's meeting. Over here is Mr. Agawas, and this over here at the end of the board table is Mr. Kalsunas, who is an alternate appointed by City Council to this board, and he will be acting as a fully voting member of this board tonight. Over on the side table is Mr. Evans, and he is representing the city administration here in the City of Troy, and then to his right is Mr. Motsney, who is an assistant city attorney for the City of Troy, and he will be, for tonight's purposes, be our legal advisor to this board. So this time, I would like to call on Mr. Evans to call the roll.
Mr. Clark.
I'm here.
Mr. Agawas.
Here.
Mr. Desmond. Mr. Eisenbacher.
Here.
Mr. Kalsunas. Mr. Lambert.
Here.
Ms. Kupa.
Here.
Okay, we have quorum tonight, so we'll press forward. I'm just going to make this announcement before I forget. So for anyone who has business items before the board tonight, we are missing one of our members, and because of that, you have the right as a petitioner to request a postponement for your item until perhaps we have a full board at the next meeting. I always like to remind people there's never a guarantee that all 7 sitting members will be here at any given meeting. We do have the power to move forward, so that is the right of the petitioner, and I'm not going to ask if you would like for a postponement for another meeting agenda. That's going to be on your shoulders to bring it to our attention. So just make sure you mention that when you are called to the microphone, if that is your choice. It is your prerogative to request it. The board does not have to agree to that, but you can certainly request it. So I'm going to call on Vice Chairman Eisenbacher now. He's going to talk about our rules and procedures for governing our board and our affairs tonight.
The Zoning Board of Appeals is a group of 7 of your neighbors appointed by Troy City Council to decide on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Petitioners must indicate a hardship or practical difficulty with the land that would warrant the granting of the variance. Procedure. The board will hear the items in the order that they appear on the agenda. When an item is called, the chairman will verify that the petitioner is present. Then the city administration will summarize the facts of the case. The petitioner will then be given an opportunity to address the board to explain the justification for the action requested. After the petitioner makes their presentation and answers any questions that the board may have, the chairman will open the public hearing. Any person wishing to speak on the request should raise their hand, and when recognized by the chairman, come up to the podium. The speaker should identify themselves with name and address, indicate the relationship to the property in question, for example, next door neighbor, live behind the property, etc., and state whether they are in favor of or against the variance request and give reasons for their opinion. Comments must be directed through the chairman. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairman to speak at one time. At the conclusion of public comments, the chairman will close the public hearing. Once the public hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, deny, or postpone the request. In order for the request to pass, a minimum of 4 votes are needed. If the request is not granted, the applicant has the right to appeal the board's decision to Oakland County Circuit Court.
Thank you, Vice Chairman Eisenbacher. We move on to item number 3, which is related to the minutes of our meeting in March 2018. Are there any comments from a member of the board or questions of staff? Mr. Lambert.
I'd like to move approval of the minutes.
Motion for approval. Is there a second? Mr. Agawas seconds. Any discussion on the motion for approval? Mr. Evans, I believe we're prepared for a vote.
Mr. Eisenbacher.
Yes.
Mr. Kalsunas.
Yes.
Mr. Lambert.
Yes.
Ms. Kupa.
Yes.
Mr. Clark.
Yes.
Mr. Agawas.
Yes.
Motion passes. We move on to item number 4, which is an administrative item for the board's consideration. Are there any changes to the agenda as presented, or is everyone happy and moving forward? Mr. Evans?
I do have a proposed change. The applicant for item B is not the property owner and has not been able to provide us sign off from the property owner to take action here. So essentially we have an application that has not been approved by the property owner. So it's our recommendation that that be removed from the agenda.
Okay. Mr. Vice Chairman Eisenbacher, you had something as well?
I was going to make a motion to remove item B from the agenda based on,
Well, it's not, we don't entertain an active motion here. We can rearrange the agenda.
motion? Okay.
Right.
Okay.
So,
remove B.
okay. So is that the consent, or basically any issue with the board members? Mr. Lambert?
One quick question,
Yes.
Mr. Chairman. The fact that we're removing it from the agenda does not affect the applicant's status, as this is a pending application that might come back to us again, or?
No, he's going to have to reapply. And
Okay.
Yeah.
Okay, thank you.
Okay, so we are going to remove item B. So we've just reduced our workload by 50%. So I think that's moving in the positive direction here for tonight's meeting. So the agenda is set now. So it's 5A, and then we go on to item number 6 from there. So we do move on to item number 5 now, and that is related to a variance request related to 580 East Waddles. Mr. Evans, would you like to present to us on this?
Thank you, Mr. Chairman. Just like to direct everyone's attention to the monitors in the front of the building. This is for a request for 580 East Waddles. This matter was postponed by this board from their March meeting. The board had several concerns. I'll talk about those in a little while. Just a brief overview of the property. This is an aerial of the neighborhood. The property is on the south side of Waddles between Rochester and Livernois. It's circled and outlined in the aerial that you see there. There's a close-up of where the property is on the south side. Now, this is the same map, and everything overlaid in that is yellow, and that signifies single-family residential zoning. So everything you see in the area is zoned and used for single-family residential purposes, including the subject property. That's a close-up again of the property. Now, the applicants provided us a sketch of the subject matter, and it involves a lot split, and he's proposing to split the property into 2 parcels, each one resulting to be 81 feet wide. Now, the zoning ordinance requires that newly created parcels be at least 85 feet wide, so he is here to seek relief from the board on that matter. At our last meeting, there were a couple of items that the board mentioned that they had questions about, and I'd like to talk about those briefly.
Sure.
Mr. Agawa had the question as to the history. Why were the 2 lots combined? We don't have the answer, but I can tell you what we have found out, that the assessing records indicate the existing house was built in 1956, or possibly before, because the city started in 1956. I've got a aerial photo from the county from 1963 that shows the existing house, and this is the approximate location of the current property boundary today. The oldest document that I was able to locate from the online County Register of Deeds search was a deed from 1978, and it confirmed the legal description then indeed was 2 lots. So that's what we know. I guess if anybody wanted a more specific answer as to perhaps when this parcel was created in its current configuration, maybe a title search might show that.
Thank you, Mr. Evans.
Okay, there's more.
Oh,
Yes.
please, proceed.
Item number 2, Board Member Lambert asked if a site condominium with 2 residences might be an alternative. In general terms, yes. The planning department, myself and the director, just sat down and crunched some numbers. Dimensionally, it appears that the necessary easement for a private road plus 2 resulting parcels that do meet the size requirements and would also meet the setback requirements, because a larger setback is required along a main road, 50 feet. It looks like it could work. So we definitely haven't ruled out that it couldn't work. But beyond that, I think if we needed to give a more specific answer, it might be incumbent upon the applicant to actually involve professionals, meet with the department, and see the viability of something like that. Let's see. Oh, number 3, there was some discussion about tree cover. And I want to point out in your agenda that that page that I'm showing on the overhead now is page 38 of your agenda. I accidentally put it under item B. So we do have a couple pictures of the tree cover, and as you know, I sent everybody a message as well to say, take a look at it. This is the GIS photo from 2017. The challenge I had and resulting in me sending you the messages, this is Google Maps, and I did this today, but I really don't know the date of that photo. I can tell you it's copyrighted 2018, but I'm confident it wasn't taken in 2018. And it's similar with Bing Maps. So those are the three items that appeared to be of concern to the board, especially the two questions from the board members. So I'll turn it back over to the board for any other questions.
Thank you. Are there any questions of our staff, the city staff? Mr. Lambert.
Thank you, Mr. Chairman. So I want to make sure I heard you correctly. You said as late as 1978 it was 2 lots?
That's the oldest document we could find on the online search, and it did
Okay.
consist of the 2 subdivision lots.
Okay, thank you.
Anyone else for our advisor from the city administration? Okay, we're going to call on the petitioner to come forward, or the petitioner's representative, or both, or all, because there's 2 petitioners and potentially a representative. So welcome.
Good evening. My name is Andrew Peterson. I'm the representative and attorney for the petitioners.
Yeah, myself, Shakur Muhammad. I'm
Good
the
evening.
owner of the property.
Good
Good
evening.
evening, everybody.
Thank you. Please proceed.
I'm aware that the board is familiar with the general facts. Just a few points in support of the variance. As went over in the summary, the petitioners are seeking a non-use variance to split the parcel into 2 separate parcels that would each have 81 feet of frontage, which is a minor difference between the 85-foot requirement. It's our contention that in this instance, compliance with the ordinance would be unnecessarily burdensome and that the petitioners would face practical difficulty. The practical difficulty arises from an exceptional characteristic of the property, which is essentially that it's ideal to split into 2 parcels other than the minor difference between the frontage requirements. The characteristic, it directly relates to the property. It's not personal in nature. The board briefly touched on the fact that at some point this property was 2 parcels previously and was combined. That wasn't done by the petitioners. They do have a letter from the previous owner that the previous owner was not the one that combined it. So basically, I don't think that fact should be held against the petitioners. And additionally, the fact that it was originally 2 parcels, I think, shows the original intent for this piece of property. Granting the variance request would essentially restore the property to what was originally intended. Additionally, granting the variance wouldn't alter the essential character of the locality in any meaningful way. There are several properties in the immediate vicinity that have frontage of less than 85 feet. The neighbor directly to the east has 81 feet of frontage. Both 2 properties directly to the east also have frontage under 85 feet. Additionally, just in the general surrounding area, there are many different types and sizes of properties. I don't think granting the variance would have any meaningful effect on the local characteristics. In fact, I think it would benefit the surrounding area and the city. It would contribute to development, for example, and increase tax values. What they're intending is basically, if the variance is granted, they would be removing the current property, the current house that's on the property, which I believe is about 70 years old, built in the 1950s, and at this point is in disrepair. So they would be removing that and replacing it with 2 brand new modern homes. The petitioners, these aren't investors who are trying to flip the property and leave. They have families, they have children, they intend to make Troy their permanent residence. With respect to the concern regarding conservation of the natural landscape and the trees in the back portion of the property. It's my understanding that the petitioners have no intent of making any significant changes in the rear portion. To that end, they would be open to any reasonable condition or restriction to that end connected with the variance. So in short, it's a very minor difference between the proposed frontage and the requirements. I think it would be unnecessarily burdensome in this case. On the other hand, if it was granted, I think it would benefit their surrounding areas. And for all those reasons, we would respectfully request that it be granted. Thank you, and I'd be happy to take any questions if there are any.
Sure. Thank you. I would just remind you in any further comments that this board cannot consider aesthetics, a positive change of aesthetics for a variance request, nor can we consider increased values, nor can we consider increased taxation or tax revenues to the city. Those are all beyond our scope. So if you mention them again, it's like talking Chinese to a person who doesn't speak Chinese or English to a person who doesn't speak any other language. We just, it's like, you know, it's not, it doesn't compute. So just be
noted.
Yeah, absolutely. And then I think you probably perhaps found a good representative to speak on your behalf, because I've never heard someone say that complying with the ordinance would bring a practical difficulty if they were in compliance. That's a new one on me. So good work on your part for coming up with a new creative perspective on the verbiage there. But I do understand your perspective in that the previous owner did not create this, allegedly. I'm not going to confirm that. But I would just ask, what would you say to one of our members' inquiry about a site condo? As Mr. Evans gave us a report here tonight, I mean, would your client be amenable to something along those lines? Because, you know, I think just looking at everything in totality, this isn't the first time we've encountered something similar to this. And, you know, I think it's happening where we see this community is, if you will, graying in that it's not an open build community. It's much more of a mature community as far as buildable sites. So I would think that maybe the site condo for you and perhaps others in the future would be a very good possible solution. So what would you say to that?
Well,
it's kind of like
I did have a chance briefly to discuss it. There are just several practical issues that I'm not sure would be feasible. The intent now, if the split were granted, is the two new homes, two separate families. They are friends, but it's two different families. From my understanding, a split condo would be an attached condo with. Well, in that respect, then I must misunderstand exactly what.
We'll let one of the members who is more familiar with it maybe address that with you, because I might think there might be a comment or a question. Mr. Lambert?
No, I was just going to mention probably Ms. Koopa or Mr. Evans probably would be much better explaining the legal concepts behind a site condo.
Sure, but wasn't this your?
It was my suggestion. Yeah.
So you just want to, because I'm not. Were you here last?
I was not.
Right. Do you want to just kind of briefly go over that?
Generally, what I was suggesting, and like I said, my colleagues would probably be better able to explain the legal situation, but a site condo is not an attached condo as traditionally known. It's more or less, it's a planning device to avoid, I believe, having to replat a piece of property, if I'm correct in understanding that. So it's an alternative way for developing property, and it's a possible way for resolving this issue of splitting the lot as another alternative. But if my colleagues would chime in with some more information, I'm sure there's a little bit more legal work involved rather than merely splitting the property. And Mr. Motzny is shaking his head yes too. So,
Mr. Motzny,
a site condo is a lot of work. Either you have you have to have a master deed and bylaws that have to be approved. You have to put in a private road. You have to provide for maintenance of the private road. It's kind of a complicated process for a 2-unit site condo. But I mean, it could be people who have done it, but is it practical? I guess that would be the question. So.
Mr. Evans, would you like to address anything on that?
It's just simply a different way to create separate pieces of land as going through the subdividing process, which originally this land was platted. But everything everyone else has said is correct.
And Ms. Koopa, do you have anything?
Yeah, the term site condo, can you just explain what that is? I know that it doesn't mean what we think it means generally. It's
Yes.
not a condominium.
Yeah, condominium describes a method of land division or parcel creation as opposed to units or attachments. So it refers to the layout of the land. So essentially, a site condo would allow a single-family home to be on a piece of land that has borders, and those borders are commonly called units. So essentially, if you're looking at a map, you see shapes of parcels, squares of parcels, you see a road, but it's just that they've gone through a different method, and it's actually a faster method than subdivisions.
If you go to page 9, I think,
Of the,
of the packet,
yeah,
on the south side of Waddles, if you go to page 9. Yeah.
right there?
So on the top left corner of that, that's probably a site condo. I mean, I'm just kind of estimating that that's probably, because what developers have done in Troy is they've taken up a parcel of land and built a string of houses. Those are site condos. Those are not, right, they're not condominiums as we in the lay terminology would use it.
Right, if you drove through there, you would not know that they're site condos.
Right.
They look just like
Single-family home.
subdivisions. They're all single-family homes with their defined borders, property borders.
So what we are saying is that one way of not dividing it into two and needing the variance would be to make that 580, a parcel of land, a site condo? Is that what I'm understanding?
Well, it appears that it would work, but we've just done a very rudimentary examination, primarily with numbers and hand sketches. But we definitely have not ruled out that it couldn't work.
So that's the recommendation. If to avoid needing a variance, that is one way of building two houses on that property. Is that what we're saying?
Well, I'm not recommending.
Okay.
And I guess
to build a site condo, I mean, we've got to vet it. There's an application process that goes before the Planning Commission. There's engineering standard, and it's as Mr. Motzi indicated, there's master deeds and bylaws. So our analysis and response, I believe a better answer could potentially come from an applicant if they were to take the time to perhaps hire design professionals, examine the zoning ordinance in detail, and really try to vet this out in a pre-application phase and possibly going before the Planning Commission in an application phase. So that's my answer.
Okay.
Well, and to just my response to that would just be, to me, and I might be wrong, it just seems like the end result would be essentially the same. It would end up with, I mean, anybody looking at the actual property would see two parcels. They wouldn't know, or I'm sorry, two houses. They wouldn't know it was split into two parcels. The concerns that have been raised, it seems, would be the same using that method as far as affecting the local character. It would still be two houses on that lot. And I may be wrong, it just seems like that would be a more costly way for the petitioners to kind of end up with the same result.
And adding to the Drew's comments. Actually, down the line, if something goes wrong, if I wanna sell my part, I have to depend on other thing also. I mean, I'm not sure like how it's gonna work in the future, to sell my property. If I go for site condominium, I don't know how it will restrict selling the property, and property value impacts the property value also.
And that's not our concern here either, about your your investment and your future value. But anyone who knows anything about condominiums, you have so many essentially shares in the greater property, and if you have, half of the shares, you're going to get that value for that dwelling and that rough area that you have use of. But that's not for us to address or even dwell upon. Are there any members of the board who would like to ask any other questions? Mr. Gauss.
I don't know if this will be a comment or a question, and this might complicate things, but what about a duplex, if that terminology is correct, and we have one combined dwelling for two households? Is that even a possibility?
No, that's not an allowed use under this zoning district.
Okay.
Any other member? Mr. Lambert.
Putting aside the whole question of a site condominium, talking about the placement of the two homes on the property, I understand you probably haven't gone to the extent of determining where those are going to be yet, but are you amenable to certain, if this board were to grant a split, are you amenable to some type of stipulation that the southern part of the property, the tree coverage, would not be taken down?
Absolutely, they would be open to any reasonable restriction, and I don't believe it was submitted, but I do have basically pictures of where the two proposed houses would be, and showing the remaining back portion. If the board is interested, I apologize. I only have one copy.
You can hand it to Mr. Lambert. We'll all look at it, and then it'll be part of the permanent record. Okay, anyone else for this petitioner?
Yeah, one more question. Originally, you say it was two lots there, right?
You can address Mr. Evans.
And they converted to one. What about was converted by the city, or who did it?
I didn't hear the first part of your question because I was talking to the city.
No, originally was two lots there.
It was two platted lots, yeah.
Yeah, and who converted to one?
We don't know. We've been unable to locate.
So now what we have here, we have one lot or we have two lots?
Well, the zoning parcel consists of two lots. So this two lots still exist, but the exterior border that consists of the zoning property.
So now the issue is not is the size of the building, right? It's not the lots.
It's the setback for the houses from the...
It looked like it's half the land, and the width is the problem. And the houses next to him, they look similar. Even some of the lots are smaller. So I'm in favor of it, to grant the variance.
Okay, thank you. Any other member for the petitioner's representative or petitioner? Okay, gentlemen can have a seat, please.
Thank you.
So I'm going to open the public hearing on this matter, even though I believe we already had a public hearing, but we'll just go ahead and allow another one. If someone would like to address the board on this agenda item, please come forward to the podium and identify yourself. If anyone would like to address the board on this matter, please step forward to the podium at this time. I'm going to close the public hearing out at this time and then bring it back to the board for further action or further inquiries of our advisors. Vice Chairman Eisenbacher.
Forgot the papers. We received one.
Oh, yes.
As I mentioned in the last meeting, we received one letter. It was placed on the table at the last meeting. This time it is in our agenda packet. I just had it open, but I jumped off of it. is,
Page 33.
yes, I just got there. Page 33 from 640 East Wattles, which is the house 3 or 4 down from the property in concern. And that's the wide property on our maps. They are concerned about splitting the large properties in Troy down to the smaller sizes, smaller than the 85 feet that's required. And then they go through the details of what the size of the house would be, which I believe is also reflected in the map or the plan that the petitioner just passed. And they do not support splitting the land into 2 parcels.
Any other communications?
I show no others.
Thank you. So now we're back at the board table with any possible action by a member of the board. Vice Chairman Eisenbacher.
The 3 most adjacent properties don't meet the 85 feet either. So I don't believe this would stand out in the neighborhood. I also visited the property and bicycled past it, past all the houses, had a look at them. What's being proposed I don't think will stand out. Almost directly across the street, there's a tear down and rebuild going on, diagonal across the street, opposite from Jennings Drive. All of the items in our criteria on page 2, I believe, are met, except for the exceptional characteristic of the property. And I would say the exceptional characteristic of the property is that it was originally 2 parcels, and it was split, and they just want to unsplit it again. The legal details of why that happened and who caused that to happen aren't available, but it appears to be much simpler to just unsplit than to go through any other process, such as a the site condo or other development process. I would make a motion to approve and see if it gets a second.
Mr. Calsunas seconds the Eisenbacher motion. Any discussion on the motion? Mr. Lambert.
I'm having, I normally don't like these lot splits. In this case, I am concerned about the fact that apparently at one time, as recently as 1978, it was 2 separate lots. What I might be supportive of the resolution if there were a couple of conditions added to it. The first would be that we would set a requirement that a certain part of the southern part of the property be set aside for no trees to be taken down. And the second would be that the side yard setbacks and front yard setbacks would be maintained, the normal setbacks would be maintained both on each side, so if the 2 houses would be a little bit closer together than they would normally be allowed, that I would be supportive of that resolution if the makers were amenable to that amendment.
Or as your unpaid Roberts Rules consultant, Mr. Lambert could at this time make an amendment, offer an amendment to the main motion, which then would be taken up before the other action. So then that member could decide if it satisfies him or her that they could then act on the second piece. So it's always like working our way down.
Then before I make that, let me make sure I have our city staff, I can clarify with them what my intent is here. And I guess the first intent is to set a point where that wooded area And I don't know, based upon the diagram they gave you, if you can look at and see about how much the distance would be that would be maintained at the southern end of the property where they've indicated where the homes are going to be.
Well, they show specific areas that they title existing tree zone. There's no measurements on there. So if we're to use their submitted diagram as a guide, there'd be a little wiggle room there just because there's no measurements. But obviously the less any submitted plans appear to comply with that, the more question the city's going to have. But there's no measurements on here for us to know definitively where that zone starts and stops. There's no tree survey.
So would it be wise to maybe, I hate to even suggest this, to postpone it to another meeting for us to get a measurement from the petitioners as to approximately where that line would be?
Well, if the board was inclined to grant a variance with this condition, it would help staff confirm not only for permitting processes but site compliance processes exactly what needed to stay and what vegetation doesn't need to stay. So it would be helpful.
And the second part would be my suggestion that the side yard setbacks on both the east side and west side of the property would be maintained normally so that the two homes would be a little bit closer together than would normally occur. Is that something that would be appropriate to put into an amendment?
When you say maintained, any application for a new house is going to need to maintain what the ordinance requires.
Okay. So that wouldn't necessarily need to be part of the motion then?
Well, I think I hear what you're trying to say is that less encroachment on the existing neighbors. Correct. Now, what I could check in the zoning ordinance is sometimes there's flexibility with, and the net result could be that one side yard is less than the other. If that's the case in this zoning district, I could at least let you know what the maximum required side yard is, and perhaps that might be something to consider. I'll look it up right now if that's okay with the board and you. Okay.
I guess I should ask while Mr. Evans is looking at that, Mr. Chairman, if the board is amenable to postponing this for another month so that staff can go out there and do a measurement on the where the appropriate area would be to protect the trees.
Vice Chairman Eisenbarger?
I'd like to ask the petitioner if they have any dimensions for that picture that was distributed. If you'd come to the microphone.
And while we're waiting for the petitioner, I do have an answer regarding setbacks. The required setbacks for side yard is 10. You can go as low as 10, but the total of both sides has to equal 20. The net effect is 10 and 10 on each side.
Okay.
So that would be the maintained setback.
Okay. Thank you.
At this time, we do not have those dimensions. It is certainly something that we could obtain, or alternatively, the petitioners would be open to any reasonable proposal of the dimensions of any portion to be preserved. But we can certainly get those and make a proposal in that respect.
Also tied in with that, is the intention to keep the front face of the house matching what the adjacent neighbors are? Like the front yard setback?
Based on, I believe, the document that I submitted, which of course does not have dimensions, just from the visual of that, it is my understanding that yes, it would maintain that.
Okay. I'm curious if the resolution could be modified such that any tree not dead or required to be removed by the construction could be maintained, if that would be definite enough for city staff.
Well, and if I may, just to clarify on that document, I believe there are some yellow dots. Those are the only trees that at this point would be required to be removed, or at least those are the only trees estimated, which I think is maybe 5 or 6 trees right around the house area, nothing in the back portion.
Yeah, when I visited the property, it looked like the trees were clustered at the rear behind the house and not so much close to the house.
Yes.
And if a similar footprint is maintained, like you indicated on the map, it looked like it was a minimal number of trees.
Absolutely. I don't think there would be any problem with that at all.
They need to maintain a 50-foot front setback from the front right-of-way line, which appears to be the front property line as it's shown in this map. So that would be the minimum they'd have to go back 50 feet from there.
And I'm assuming all the utilities are from the front and exist, so wouldn't need to retrench from the back.
I don't know.
Yeah, we don't know.
They might know more than we do.
Yeah, it's their property.
I know we've already delayed this 1 month.
I was going to say, I would prefer if we could come up with a resolution that we could live with that would allow Mr. Evans to do his job well and not postpone it. So,
Would it help if the board members saw the diagram again? I can pass it down, and perhaps a visual will assist in coming up with some language.
Thank you.
We could work with that, but the preciseness is, going to be compromised.
Do you have the rear setback number there?
I do. 40 feet.
Oh, yeah, it's bigger than 40 feet.
Oh, yes.
Scale the drawing.
Can't really tell.
Yeah, it's the yellow dots.
Mr. Chairman?
Mr. Lambert, please.
I'll put Mr. Evans on the spot then. Your preference would be to have staff go out there and measure the exact dimensions?
Well, to avoid any question as to whether or not the construction documents and the project, and when it's completed, satisfies the board's requirements, measurements would probably be the most exact for planning stages for the applicant, city review, as well as when the staff goes out to take a look at it when it's done, or in the future, someone decides they want to take trees down on that site, we can point to something definitively and give a clear answer to anybody who wants to know where can and where can I work. With that being said, if the board wants to have a comfort level with perhaps a buffer zone in the back, maybe you could specify perhaps an amount from the rear property line northward, and then that area, and ultimately if they find in their planning process that it doesn't work, they can come back and explain why it doesn't work. But possibly that might be one way to get some number here that satisfies that buffer, keeps it there, and we can all know going out of here that it's the back X number of feet that has to remain tree.
Mr. Lambert?
Then I'm going to move that we postpone this to our next meeting so staff can take some accurate measurements out there and possibly work with the petitioner's attorney or any additional staff that go out there, and they would have an agreement as to what would be an appropriate buffer zone back there, and to answer Mr. Evans' question, whatever that might be.
Yes, and I hear staff. The applicant's heard everything here tonight and has as good idea as anybody as to what needs to be done. In addition, clearly they've given it some thought as to where the existing trees are now. I think it's incumbent upon the applicant to come back and provide information rather than have staff attempt to assess what works and what doesn't, because ultimately It's the board that has to be comfortable with the proposal, and any conditions imposed in any potential variance request, they can differ. And so really the applicant, I think, can provide the most accurate assessment.
With that clarification, then, my motion to postpone is so moved.
There's a motion to postpone to until next month's ZBA meeting. Is there a second? I'll second. Any discussion on the motion? Vice Chairman Eisenbacher.
I'm concerned when we can't take prompt action. Just because, looking at this picture, I can tell that this is, it's more than a third of the property. I think we can create a number that would provide for plenty of buffer for the neighbor that had the concern and spoke at the last meeting, and still meet the needs of the neighbors, basically. And get a decision tonight instead of postponing it to a third month. That's it.
Or wait to get some more information, like namely mathematical information that engineers normally use in their profession.
Rule of thumb.
I'm an engineer, but I tend to agree with Mr. Eisenbacher because I think efficiency is also important. And the more we postpone, we should be efficient as a board.
Anyone else on the motion to postpone? Seeing none, Mr. Evans, I believe we're prepared for a vote.
All right.
So this is a yes vote, it postpones this agenda item until next month's board meeting. Please.
Mr. Eisenbacher,
No.
Mr. Kaltsunis,
No.
Mr. Lambert,
Yes.
Ms. Koopa,
No?
Mr. Clark,
Yes.
Mr. Gauss.
No.
The motion is rejected, so we're back to the board table. Vice Chairman Eisenbacher.
I would like to make, your amendment was seconded, right?
No.
Okay. I would like to make an amendment to the resolution that,
Well then, let me just
okay,
interject. So the motion is yours.
great. I'd like to amend it.
So you can't amend your own motion, essentially. You can then have a friendly change if the seconder to the motion is in agreement with you. So why don't you state what
Okay.
you would like to
What I would like
essentially,
to update
right?
is that basically that yellow print shows about 2/5 of the length is yellowed. I'd like to make the rear third of the property, given that it's 270 feet, 270 divided by 3 is roughly the rear 90 feet. I'd like to make it where no non-dead trees, because dead trees are a safety risk especially for children and the neighbors if they fall on the neighbor's property, no non-dead trees be removed from the rear 90 feet of the property for construction.
And who was the seconder? Mr.
Kaltsunis.
Kaltsunis? That was your,
Said that.
so that's the new motion.
Incorporated in. We already
Right.
have the setbacks as being 10 feet on each side, symmetric,
And 50 in the front.
and 50 in the front, yeah, by the ordinance.
Is there any discussion on the revised motion? Seeing none, Mr. Evans, I believe we're prepared for a vote.
Mr. Gauss,
Yes.
Mr. Eisenbacher,
Yes.
Mr. Kaltsunis,
Yes.
Mr. Lambert,
No.
Ms. Koopa,
Yes.
Mr. Clark.
Yes. Motion passes. Congratulations, you have your variance. So we move on to item number 6, related to communications. Mr. Evans, do you have anything for us here?
I do not.
Okay, we move on to item number 7, miscellaneous business. Mr. Evans, do you have any other business for us?
I owe you a staff report from last month, which was a further breakdown of variances relative to residential building permits, but so I owe that to you.
Okay, no problem. I would just make a comment. Mr. Evans, will you please confirm that on our May agenda, we will have board elections next month? Is that correct?
I believe it is, yes.
That comes every May. So chairman and the vice chairman positions are open. Just to remind members of the board, either a combined motion for a chairman and a vice chairman can and be entertained, or separate for each office, so essentially bifurcated. So essentially the rule of thumb is if there's a motion for 2 parties to be chairman and vice chairman, that would be entertained unless somebody else made a second motion to nominate someone just for, you would start with chairman first, and then that essentially bifurcates that, so it kind of supersedes the combined motion. So just either are an option, and there isn't one that is a preference other than to the member making the motion. Any other members on that? Mr. Lambert.
I give a job to Mr. Motzny. He may be able to do it right away now, or he may have to spend a week doing it. But if for some reason we have no business items in May other than the election, do our bylaws require us to meet that night just to hold an election, or would it be postponed till our June meeting? And you don't have to answer it tonight.
I can give a partial answer. I know we've got at least 1 application.
Okay. All right. That solves that question.
If it turns out that that person withdraws or otherwise, I'll turn to Mr. Motzny for our answer.
Look into it.
Yes.
Okay. Mr. Lambert.
This is not related to that question. It's just to thank Mr. Motzny for sending us the information from, I guess, Micah Myers law firm, giving us some more information on variances. I appreciate you sending that to us.
Good night. Tell
I just
tell
want to
the young
add
one that we enjoyed her dancing. It was very fun.
I also want to, as a mom, I know how hard it is to keep your children quiet in a meeting, so I really wanted to appreciate that. And I also wanted to appreciate all of you for bringing your children. I see another father here. Bringing your children, because this is government at its best when you educate your children from a very young age, what is civic engagement. So coming here and having them sit with you in support of a neighbor, it was great.
Thank you.
So.
Mr. Lambert?
That's it for me.
Oh, I thought you had one more thing.
Nope.
Vice Chairman, I thought it was somebody over here. No. Okay. Anyone else on miscellaneous business before the board? Seeing none, we'll open the public comment to the board on any item. So that portion is open for anyone who would like to address the board under public comment. Once again, public comment to the board, please step to the podium and address the board on any matter that you'd like. I'm going to close that portion out. And we are set for a meeting next month that may be short, may be longer. We'll see what Mr. Evans puts together for us. So have a very good night, everyone.
Thank you.